Good afternoon, everyone. Welcome to our first March webinar of 2026, Protection from Liability. My name is Alina Gilbert. I'll be presenting this one today. And as always, before we get started, I do want to go through a couple of housekeeping items for those of you who have not yet done one of our webinars. So on your screen, what you should be seeing is mostly the PowerPoint with my little cartoon meme. And off to the left is me, the presenter. Hello. And on the right side of the screen, there is an icon for chatting. It's a private chat icon. That's where you go if you have questions as we go through the presentation. I will respond to questions at the very end of the presentation, assuming we have time left. I want to be very respectful of your time. You're all busy, and we will end this by 1 o'clock, and hopefully we will have time to get through any questions as well. If you are having any audio or any video problems, there is a little icon on the bottom that says audio video problems. Click on that. That'll take you through a few steps, hopefully resolve whatever issues you might be having. You will get one CMCA certificate for attending this webinar as long as you're on the whole time. Our webinar provider actually tracks how long people are on. So if you don't see an email with a certificate, it might mean you weren't on the entire time. So just make sure you stay on until we're done. And the certificate will, again, come in email, and you need to save the actual certificate to your computer because after about 30 days, it disappears. It goes away. I don't know why it does that, but it does. So please make sure you're saving a copy of the actual certificate itself so it doesn't go away. Just as a quick reminder, this is being recorded. This will be posted on our YouTube channel probably by tomorrow. And so if you want to recommend this to anybody or you want to watch it again, it will be available free of charge. We just cannot issue any credits for folks who watch it as a recording. And lastly, but never least, at the end of the presentation, you will have a little feedback link pop on with some questions about the webinar, about me, about the content. To the extent that you have time and you are willing to, please provide us with any feedback you have. Again, all this stuff helps us improve our presentations to you in the future, and we do review all the feedback. So, please let us know what's working, what's not working, and any thoughts you have. So thank you. And let's, at this point, go ahead and get started with the main stuff. All right. So I always like to start very broad before we get to protecting you from liability. Let's talk about what liability really is. And we all kind of think we know what it is, but I think it's nice to be on the same page when it comes to these sorts of things. So liability, if we look at Black's Law Dictionary, which is kind of like the main dictionary that attorneys use to define legal terms, it defines it as the state of being bound or obligated in law or justice to do, pay, or make good on something. We'll talk about what that means in plain English here in a second. And when we talk about liability, it often leads to compensatory damages to make the victim whole, which generally means if you're liable for something, you're probably going to have to pay them some money. Or it can lead to non-monetary rulings based on equity, which means you might be required to take a certain action, not pay money, but take a certain action to make the victim whole. And these obligations are based on law or on equity. So essentially what it means is the association did or didn't do something that it should have done or should not have done, which caused damages to someone else. Now, those damages could be money damages, or it could be, for example, the fact that I wanted to put up a tree house and I wasn't allowed to do it. Please, judge, tell the association to let me put up a tree house. That would be a ruling based on equity that would not necessarily equal money, but it would be the court saying, bad HOA, let the owner put up his treehouse. Okay, so when we have these types of liabilities, they're based on law, where someone breached the law, or they're based on equity, which means it's not fair. The results or what happened wasn't fair. And, no one's entitled to fairness. We always say life isn't fair, but I think this is a sense of like legal fairness. And we'll talk about some issues in more detail and what that means. We also have to realize that there's different types of liability. We have civil liability, which is essentially wrongs that are not based in any criminal actions that result in damages. And this is really primarily what associations deal with. Most of the time when associations are accused of something or sued over something, it's not related to any kind of criminal allegations. It's more of, you did something wrong from a civil perspective. You didn't follow your documents. You didn't, you didn't act appropriately when it comes to, performing maintenance, things like that. There's also professional liability, which we see a lot, for example, with attorneys, with management companies. It is basically mistakes made by professional service providers that also result in damages. Again, we don't deal with that a whole lot from an association perspective because associations are not deemed professionals. And then there's criminal liability, which we definitely don't see very much of when it comes to HOA liability. And just for clarification, the class today, we're going to focus on HOA liability. I'm not going to focus on liability of, managers, liability of homeowners, liability of attorneys. I'm only focusing on the liability of the association as a whole and individual directors. So I want to make sure that you kind of keep that in mind as we go through this presentation. So what are some common causes of liability with respect to HOAs? I'm sure you all have lots of examples, and you could all type them in. You don't have to, obviously, but I'm sure we all have lots of examples. In general, what we see mostly is allegations of negligent or willful actions or inactions. So examples are what? You didn't maintain the roof, I got a leak, and now association, you have to pay for my interior unit damage because it's your fault. We see a lot of allegations of failure to follow the law or the governing documents. You didn't properly impose the special assessment. The governing documents require homeowner approval. You didn't get it, and therefore I'm not going to pay the special assessment. So we see those types of claims a lot. We also see contract breach type claims. Now, a lot of times that could mean a contractor sues the association because the association didn't pay its contract price, or the association terminated the contract prematurely and the contractor wants liquidated damages. And a lot of times when we think of like the declaration as a contract itself, sometimes you will see homeowners claiming contract breach by the association if it fails to comply with the terms of the declaration. So that could also be a cause of action. And then the other one is a breach of fiduciary duty. I'm sure you have heard that a lot from owners and residents. You're breaching your fiduciary duty. Most of the time, people don't really know what that means, but essentially it means you're not acting in good faith. And just as an aside, what is a fiduciary? A fiduciary is someone who is entrusted with the assets of another. to basically take care of those assets. So how does that come into play with our associations? Well, homeowners pay assessments, right? So the association is basically taking the homeowner's money, and the homeowners are entrusting the association to take their money and then use it for appropriate purposes that are set forth in the declaration. So in that sense, associations do become fiduciaries, as do individual board members. So it is an appropriate term to use. All right. Oh, you know what? I'm trying to forward this. I'm trying to forward this PowerPoint. Here we go. Let's try this again. There we go. All right. So this is a little laughter for you. I know it's a little out of season, but it's a hippopotamus, and I really don't think hippopotamuses are ever out of season. So let us move on then. We're now going to transition to protections from liability. We've just talked about what liability is, what it looks like, what it could arise from. So really what this class is intended to talk about is how do we protect, excuse me, the association? How do we protect individual board members from liability? And I don't know what's happening to my voice either. Oh my goodness. Okay, I think it's back. So let's talk about now different ways to protect associations from liability. And really what I wanted to focus on in this class was statutory protections from liability. This is how we describe the class. And there's different forms of statutory liability. Sometimes it's a matter of having certain provisions in your documents. Other times it's being aware of provisions in the statutes that say if you do X, you are protected. So we are going to cover all those different things in this presentation. Okay, so the first thing I want to talk about is a limitation of liability clause in the Articles of Incorporation. This is out of the Nonprofit Act. I have a citation in there for those of you who really like looking things up. So feel free, you can get a copy of the Nonprofit Act on our website, and that's the section. But basically what this provision of the Nonprofit Act says is if you have a provision in your Articles of Incorporation that the board will be protected from liability for monetary damages that arise out of the breach of their fiduciary duty. Now, or a breach of other duties. There are exceptions to this, but basically what this says is as long as you have this provision, you should be protected from liability as a board member based on things you do that perhaps are wrong, inadvertently incorrect, that you may not realize is wrong. But the exceptions are if you are breaching your duty of loyalty to the association, so you're not acting in a manner that you believe to be in the best interest of the association, you're acting in a manner that's really based on your own self-interests. It's not going to protect you if you are not acting in good faith or you're acting intentionally in an incorrect manner. That you're not going to be protected if you're knowingly violating the law. You're doing something that the law does not allow. You knowingly are doing this. This isn't going to help. And also improper personal benefit for a board member. So yes, in order to have this protection, you first need the provision in your articles, but also you need to be acting in good faith in a manner that you really believe to be correct and in the best interests of the association, even if it turns out that what you're doing is not technically correct or it doesn't end up benefiting the community, you can still be protected from liability. So a lot of times when associations ask us to look into their documents and see kind of whether or not they need to be amended, the first thing we look for when we're looking at the articles is this provision. If you don't have it in your articles, we will typically say, hey, we would recommend rewriting your documents or your articles at least, just to get this in here, because you guys aren't getting paid enough to not have all the protection you can get. That was a joke. You're not getting paid enough. Ha. All right. What else? So now let's talk about the standards of conduct. The Nonprofit Act, and there's the site for you again, also contains I shouldn't say very specific. They're specific and yet not specific at the same time, but standards of conduct that if board members follow these standards of conduct, they will not be liable for any damages. So what are they? There's really three things. There's acting in good faith. There's acting with the care of an ordinary, prudent person in like position and in a manner reasonably believed to be in the best interests of the corporation. What does all that mean? Great question. So acting in good faith. That means, again, you are not acting for personal gain. There are some very clear examples, while others aren't as clear. The clear example, and I see this sometimes, is you have a board member who says, we've had damages in the community. I want you to fix my unit first. No particular reason. Because I'm on the board, I want you to fix my unit first. Or I want you to fix my unit even though the association isn't obligated to fix unit interiors. I have seen this more often than I would like. And it's absolutely a huge exposure to liability to the board and the board member who is asking for this to be done to his or her unit. But that is not acting in good faith. The care of an ordinary prudent person in like position. So this is an objective standard, and it talks really to the typical, sensible, reasonable person. What is that? Does anyone really know? I mean, it's kind of like you know it when you see it type of a situation. There are no specific measurable guidelines in statutes that talk about you're reasonable or you're objective or you're sensible if you do X, Y, and Z. It is a standard that if you are sued, that the judge would have to decide whether or not you have complied with the standard. And so it's kind of like if it doesn't feel completely right, it probably isn't. And it probably isn't going to be something that the typical sensible objective person is going to do. And unfortunately, there's really not much more guidance other than we look at other court cases to see when or if courts have deemed certain actions to not be the prudent person in like position type of actions. And that's really all we have to go off of. So unfortunately, like I said, there's no like checklist I can give you that says you're objective and sensible if you do X, Y, and Z. It's kind of like you got to have some common sense and you need to think about it. And if it feels icky, it's probably not going to pass the test. And then there's the manner reasonably believed to be in the best interests of the corporation. Again, this is also on some level going to incorporate that reasonable person status, because you have to reasonably believe that what you're doing is in the best interests of the corporation. But with this one, courts will oftentimes give deference to the boards with respect to decisions, because hindsight's always going to be 20/20. And when you're in a situation where you got to make a decision, we can't see the future. So as long as we can explain a fairly reasonable rationale as to why the association did what it did, courts will usually say, okay, we will defer to you on this one. So again, it just has to be something that can be reasonably explained to somehow benefit the association. I had an association adopt a rule that garage doors have to be closed at all times except when you're entering and exiting your garage. It was something that homeowners weren't particularly thrilled with because a lot of them wanted to keep their garage doors open. They wanted to do work in the garage. They didn't want to suffocate. They didn't think it was a reasonable rule. There was a challenge to the rule. And the question from the court was, what's the purpose? How does this benefit the community? The board came back with, we've had some criminal activity in this area. There have been some thefts, there have been some break-ins, and we believe that having a garage door open is an opportunity for those types of criminals to enter a home and commit crimes. And therefore, this is why we thought it would be in the best interest of the community to require that the garage doors stay closed. And that was fine. I mean, it might not be the best reason if you think about it logically, because if you have somebody in the garage, nobody's going to try and run in through your garage and enter a unit. But, again, hindsight's 20/20. But the court thought that that was an appropriate reason because it was logical. It made some sense. And so the court gave deference to the board and its thinking. So in that sense, again, as long as you can reasonably relate the decision to some kind of a benefit to the community, to the homeowners, the membership, you should be able to get deference from the courts. All right, this is one that I am really big on, and I always like to talk about it a lot because this is an easy way to protect yourself. And for some reason, I get pushback from boards, sometimes from managers on this, and mostly because of cost. But here's the deal. Again, this is the Nonprofit Act. It says that a board, when making its decisions, can rely on expert opinions. Okay? They are entitled to rely on expert opinions. If the decision is based on an expert opinion, you are not going to be exposed to liability as a board or as an association. So to me, this is kind of a no-brainer. Okay? I'll give you an example. There was recently a leak in a basement of a townhome. And in that case, the association actually was responsible for the foundation, not necessarily the finished surfaces inside, but like the foundation. And there was a leak in the basement, and the homeowner had their own contractor come and look at the basement. And their contractor said, yeah, you need to fix this. There's all these cracks, and here's what it's going to cost. So the homeowner gave that to the association and said, here, fix this because you are responsible for fixing and maintaining the slabs. And the association said, oh, well, I guess we better fix it. But what they didn't do was they did not reach out to their own contractors to come and inspect and give them an opinion as to whether or not something needed to be done. And the problem with that is they did not perform their due diligence, and they were just going to rely on the opinion of the homeowner's contractor, who was not our expert. That is someone who was paid for by the homeowner, not by the association. The manager told the board, well, we probably need to have someone come out on our end and take a look at everything. And the manager was absolutely correct. And the board said, well, we don't want to pay an expert. We don't want to pay someone to come out and do it when someone's already looked at this. And therefore, they were just going to go ahead, bend over, pay, I think it was like somewhere around $35,000 or $40,000 for work to this foundation without ever double checking to make sure that this was appropriate. And eventually it did come to us because there was some kind of conflict between the homeowner and the association. And we looked at it and we said, well, hold on. Why are you automatically doing this? Have you had your own contractor come out and inspect it? And the board said, no, we don't want to pay. And we said, well, it's a very small price to pay for being absolved from liability. And so again, when we don't know exactly what's going on, we cannot just rely on contractors from homeowners. We need to get our own experts in there. And it could be a structural issue. You know, we might need a structural engineer. It could be some sort of a landscaping issue. It could be a legal issue, whatever the issue is. If it requires us to get informed, which most of the time it does, you need your own expert in there to tell you, here's the situation, here are your options moving forward, here's what we recommend. Doing this and following that expert protects the board from liability. Guess what? Even if that opinion is way off, that opinion could be completely wrong. The board will be protected because it relied on the expert. Now, if you look at these bullets, you have to reasonably believe the expert is qualified. And there is an exception where relying on an expert who you have information about that would make reliance unwarranted if you do that. So for example, I'm going to get an attorney opinion from this attorney who was recently disbarred for not, giving appropriate opinions. Well, A, they're not an expert because they're disbarred, but B, they've made a lot of mistakes. So, relying on that would not be appropriate, but relying on someone who is an expert, who isn't good standing, is appropriate. And if we give, or any law firm gives an opinion and we say, you have to do X, Y, and Z, or we recommend you do X, Y, and Z, the association does X, Y, and Z, and then later, guess what? That is not correct. Of course, that wouldn't happen with our opinion, but so the association is still going to be protected from liability, as will individual board members. So to me, I don't understand this resistance of board members to getting informed and making a decision based on their professionals' recommendations. Yes, it costs more money, but ultimately it will save you money later on if there is some kind of a lawsuit. And again, you board members don't get paid enough to put your liability at risk, to put yourself out there. It's just not worth it. And so get the expert opinion, rely on that opinion, and follow it. You will be protected. All right, I think I am done. I think I'm off my high horse now. So let me go on. All right, indemnification language. What is indemnification? So it's a little bit different than liability, but basically what it says is, if you as a director are named in a lawsuit personally, the association will step in and pay for all the legal costs associated with your defense and damages, if there are any. So it essentially is a method to keep money from coming out of your own pocket as a director by requiring the association to pay. Now, how does the association pay? It pays from insurance, and we'll talk about that in a minute. But the requirement of indemnification, there is language in the statute, but if you have something different in your documents, you're really going to go off what your documents say, because what the statute says is unless it's otherwise provided. So, and I Again, here's the site to the Nonprofit Act. It's all Nonprofit Act. And if you just have the minimal, what could happen is a lot of times the language that you have is not, or it is discretionary. It basically says, if a director gets sued, then the remaining directors get to decide whether or not that individual is indemnified. And so if you happen to be the one person on the board that nobody likes for whatever reason, and each board member gets named in a lawsuit, it is entirely possible that the board could say, well, we're not going to indemnify Bob because we don't like Bob and we don't think he acted appropriately, and therefore he doesn't deserve indemnification, so we're not going to agree to it. We don't want that kind of discretion with the board. We really don't, because then it becomes a popularity contest, and we don't ever want that. If you're entitled, if you're a board member and you're getting sued over something you did as a board member, you are entitled to be indemnified by the association. So one of the things we want to make sure of is that the indemnity language does specifically require the indemnification, and it's not the board gets to decide. The other thing that we want to make sure that indemnification language contains is a duty to indemnify up front. So what does that mean? It means that if I get sued as a board member because the allegation is I breached my fiduciary duty to properly have the windows maintained, I'm just making this up, and I go to court and I say, board, indemnify me, and they say, well, we're going to wait to make sure you don't get, the court doesn't decide that you actually did something wrong before indemnifying you. So you got to pay everything up front. And then if the court says you didn't do anything wrong, then you'll get reimbursed by the association. We certainly don't want that to be the situation. We need to have board members indemnified just as soon as the legal fees start, right? We don't want board members having to spend money out of their own pockets to pay an attorney to defend them when they're getting sued over something they did as a board member. So we don't want to wait till the end for them to get indemnified. They need to start getting indemnified from the beginning. There's a lot of other little things here and there. Those are the two big ones that I see when associations don't have kind of like that indemnification language that is strong. So that is something we recommend. Now, there's exceptions, as you can see. There are exceptions to the indemnification, and the Nonprofit Act specifically says, you don't get indemnification if you've committed a criminal action. So what does that mean? It means, so sometimes somebody could get accused of a criminal action, and then the association might have to pay for the legal fees. And if the individual is found guilty, then the association seeks reimbursement, which isn't really great, but it's not that often that we see board members being found guilty of criminal actions, but it could happen. But you don't get indemnification if you're committed a criminal action. Problem is, you haven't committed a criminal action until you're found guilty. You also aren't entitled to indemnification if that action was not made in good faith or you've otherwise violated your fiduciary obligation. This is why a lot of times I have to tell boards, like I'll have a manager call me and they say, this is what the board has to do. The board is refusing to do this. They're not following our advice. They're not following your advice, legal counsel. And we don't know what to do. And what I always like to say is, well, the board may want to know that if they are taking actions and purposely not following the advice of their experts, they are not only exposed to liability, but they may not be entitled to indemnification. So if they get sued, they may end up having to pay their own attorney legal fees to defend them. Okay. So again, these are things that the statute says you're not entitled to indemnification for. So we want to make sure that whatever language you have in your documents, that it uses the strongest possible language as far as protecting our board members, but also does still contain exceptions with respect to certain kinds of actions that the statute says you don't get indemnification for. And it's important also to read through your provisions to see that if someone is charged with a criminal action or someone is charged with not acting in good faith, do they still get the benefit of indemnification until they are adjudged and either found guilty or found to have breached their fiduciary duty? That is also an important provision, and you probably want to know what your governing documents say about that. We had a court case years ago, but it was a former board member who got sued. It was something to do with yelling at someone at a pool, right? That never happens. And this prior board member got sued for what they did while they were on the board. And the current board said, no, we're not indemnifying you. You yelled at someone. You weren't supposed to do that. And you're not entitled to any indemnification. And so then that person sued the association, demanding indemnification and demanding reimbursement for any legal fees he incurred. And at the end, when all is said and done, that individual did get the indemnification. So it's important to know what's in your provisions. If you haven't read through your indemnification provisions, just take a glance. It'll help with your insomnia, but it might, also help you understand what specifically is required for your community. All right. And now, something very near and dear to my heart, insurance. I love insurance. Most people hate insurance. It is about as easy to understand as legal stuff, although worse. So it is absolutely necessary for associations to carry appropriate liability insurance. Now, real quick, this is very different than your property insurance. Property is basically if you have, some sort of a catastrophic event and then there's damage to the buildings. This isn't what we're talking about. These are liability exposures from wrongdoing, right? Not from some kind of a catastrophic event, but from wrongdoing, like we talked about at the beginning. It's a civil liability. You, association, did not properly maintain something, and now I have damage, or now I am having health issues because you didn't clean out my mold. I slipped and fell on the ice. You didn't properly clean off the ice on common areas, so now I'm suing you. It's those types of claims that fall under the liability, and that's really what we're talking about here today. So for communities created after July 1, 1992, which is when Kiowa came into existence, and as you all know, Kiowa is the statute that governs HOAs. Those communities are subject to Section 313 of Kiowa, which is all insurance all the time. And it absolutely requires associations to carry CGL, which is commercial general liability coverage, which covers you again for those slip and fall incidents, for those, hey, the board didn't let me put up my treehouse, tell the board they have to let me put up my treehouse judge type cases. And so that would be the CGL. Now, and so that's a requirement. So whether or not you want to carry it, whether or not your declaration requires that you carry it, you have to carry it if you're post 1992. If you're pre July 1, 1992, you only have to carry it if your declaration requires it. But regardless, if your declaration is completely silent, you should always, always, always be carrying your liability coverage regardless, because again, this is what's going to fund the indemnification and the insurance and the defense of the association. The association does not generally have hundreds of thousands of dollars or millions of dollars to pay attorneys, and then damages if they're awarded to the victims. And so where does that money come from? It comes from your insurance. And so even though this doesn't necessarily protect you from liability, it is a liability protection because it protects the association's funds and it protects you from having to go bankrupt. Okay. D&O, directors and officers liability coverage. What is that? Well, that's when the directors, officers, it's going to include your community managers, your committee members, your volunteers, anyone who does work on behalf of the association. This is coverage for them if they get individually named in a lawsuit, again, alleging that they did something wrong, they acted inappropriately, and they caused some sort of damage to, whether it's a resident, whether it's a guest of a resident, it doesn't matter. So the D&O and the CGL policies, all associations should have. Ironically, directors and officers is actually, it's not required by Kiowa. I've never understood that. Kiowa requires general liability, but not directors and officers. To me, that's absolutely ridiculous. I would not serve on a board of any association that does not carry a directors and officers liability policy. If you're not sure your association carries one, you better make sure, because it's just not worth it otherwise. We always want to make sure that these liability policies cover both monetary and non-monetary claims. Sometimes, like we said before, you are going to get sued over what? Over, I want to put the treehouse up, or I want to put up the fence that the association's not letting me put up. I want to do xeriscape in the front yard and put, astroturf in there, and the association won't let me. There's all sorts of examples of non-monetary claims, and you always want to make sure that your policy covers both monetary and non-monetary costs. You want to make sure that your defense costs are outside the policy limits. So what does that mean? I have seen an association had about, I think it had a $1 million total liability policy. That was it. That's all they had. And the legal costs were within that cap, which means, whatever you incur in legal fees, it's all going towards that $1 million. So let's say you incurred $300,000 in legal fees, which is not an outrageous number for some complex lawsuits. You're incurring that much in legal fees, that leaves you with $700,000 for everything else. What happens if you get a judgment against you that's more than that, right? So it's always better, because we never know with legal fees, things happen, things come up. Some lawyers on the other side love to stretch the process out and have, the other side bleed legal fees by filing motion after motion after motion. You want to be able to not worry about the legal fees eating up that policy limit. And so we always try to make sure that your policy is one that says your defense costs are outside that limit of liability that insurance will pay. We always want to make sure you have at least $2 million of aggregate coverage. Why? Because everything's expensive these days, and some of the awards, especially if you have like a jury, can be outrageous. And umbrella coverage, not required by Kiowa, probably not required by your documents, but is it necessary? I would absolutely recommend associations get that. It is basically coverage over and above what your liability policies cover. So here's the story I like to share with folks, and I experienced this many years ago when I was still early on in my practice of law in this industry, where there was a slip and fall in a community. It was a jogger. He slipped and fell. He was an older gentleman. He had a lot of medical issues after that, sued the association. The association had a $2 million policy at that time, but they did not have an umbrella. The jury, this is a jury trial, felt really bad for the old dude, and they issued a judgment against the association for $4 million. $4 million. They had a $2 million policy. They did not have an umbrella. If they had an umbrella, the umbrella would kind of kick in and then pay anything that's over and above the $2 million policy limit that they had on their regular liability policy. They didn't have it. Anyway, it was not pretty. So it's not worth it to not have it. My understanding is that the cost of an umbrella policy is small compared to, you know, the rest of your policy, and it's very affordable, and it's just not worth taking the chance to not have the umbrella policy. So again, protect the community and the board members, everyone from liability and from money coming out of their own pockets by having the appropriate liability coverage. Again, if you're not sure, I always recommend you can talk to your insurance representative. Hopefully they're an HOA insurance professional. You can have a lot of, I don't know, firms, law firms can provide you with an insurance audit. I know that's something we do, where we basically would review all your policies, including your liability, including the hazard property policy and all the endorsements, and prepare a report as far as like, here's what's required, here's what you have, here's what's recommended, here's what you have, here's our recommendations, here are things you should watch out for. So that's something you can get prepared. I'm sure most attorneys in the industry can do that. So that's another thought if you are worried that you don't have the adequate coverage that you need. All right. So that was my last kind of big protection from liability spiel. But I do want to say that we all need to remember that protection from liability never means you're not going to get sued. The problem here is anyone can sue anyone for absolutely anything, whether it's a viable cause or whether it's completely frivolous. The way our law is, anyone can file a lawsuit. So when we talk about protection from liability, we're not talking about the fact that if you do this, you will never get sued. That's not what we're saying. But what we're saying is if you do this and you do get sued, a judge is not going to say that you did something wrong. Or if you do this and you get sued, you will not be spending money out of your personal pocket to defend yourself for something you did on behalf of the association. So that's really what this is about. And it's very important to understand that distinction, because I think a lot of folks kind of struggle with that. They really think, well, if I do this, I'm never going to get sued. And that's just not the case. You know, we have a litigious society these days. There's a lot of people filing lawsuits over silly things. And they're not successful, but they do file them. And it does require associations to then be represented in many cases in court, and that still costs money. And so ultimately we want you protected from being responsible for something or being held that you did something wrong, and we want you to be protected from spending money out of your own pocket. And that's what this presentation is really about. And I do have questions, and I will try to start at the very beginning. All right, let me just get us to the last slide with the dancing chicken, the dancing pig. Enjoy. I will start at the bottom and go through all these go through as many of these as I can. In a gym with no human spotters, would it be wise to have a power bench rack with spotter bars, safety bars? What about squat, power rack, and safety bars? So this is actually, it's a really good question, because it kind of goes to what steps do we need to take when we have facilities to protect us, the association, from liability. And it's kind of counterintuitive, but a lot of times what I would recommend is basically saying, hey, there's nobody here watching, there's nobody here to protect you. You need to take whatever steps you need to take, and you use all of this equipment at your own risk. Now, do we want to install, whatever safety bars? Sure, you can install those. That's great. But ultimately, we always want to tell people that, no, you're using this at your own risk. Don't rely on anyone like coming in and saving you. Okay. So that would be my recommendation, and certainly not a bad idea for the safety bars. We talked about this. Is there a legal test of good faith as it would apply to HOA boards? And again, we did talk about this. There is obviously nothing like that. It's the common sense approach, unfortunately. But that was a good question. Insurance policies often have exclusions for providing directors legal representation if they knowingly violate the law or governing documents. Is that supported by legal precedent? Yeah, that goes hand in hand with that indemnification language we talked about just now, and that under the Nonprofit Act, associations are not required to indemnify directors who have acted in bad faith or who have acted in a criminal manner. So absolutely, that goes hand in hand with the Nonprofit Act. What if board members feel the association is too focused on liability, rents a bouncy house with no requirement for the service provider to name the association as an additional insured, and doesn't require participants to sign a waiver? Is the board member meeting their fiduciary duty or acting reasonable or in good faith? So I think it depends. I think who's renting the bouncy castle, I guess. If it's the association, that could be a problem. If it's an owner who's having some sort of an event and the bouncy castle is on their property, I don't care. That's not our issue. If it's on common area, it could be an issue. If to the extent, though, that there's any activity that the association either allows on common area, we need to have special events coverage for those types of events. If anyone gets hurt on the property and you're not requiring the person hosting that event to carry the special events coverage, we got to have it, because your regular liability policy will not cover that. So you definitely want to make sure that you're doing something, and I would recommend consulting with legal counsel in that sort of a situation, so you can get advice on how best to move forward, as well as talking to your insurance representative as to what you can do. So maybe we'll cover this, but I read that in an Altitude article that can't require a person under 16 to be accompanied by an adult in the pool area. Does that mean we have to let kids under 16 go in the pool area alone? Another great question. So fair housing laws basically consider that to be discrimination based on familial status, which means based on the structure of the family. If you have little kids, we're going to treat you differently than families without kids, for example. And that has been found to be a violation of fair housing laws. But what you can do with the pools, you can't necessarily do this with your workout room, but with the pools is you can have a rule that says anyone, you can't really go above 12, but anyone who's 12 and under must be accompanied by an adult for safety considerations, unless they can demonstrate swimming proficiency by providing the association with some sort of like Red Cross certification or other proof of swimming proficiency. Because again, we're allowed to have rules based on safety concerns, but it can't just be based on age. So we have to allow for the possibility that I am a 10-year-old, for example, who is on my swim team and I can swim better than any of the adults here. We have to allow for that possibility. And if that's the case, and I can show my Red Cross card or whatever thing I have that demonstrates, you don't have to test them for swimming proficiency. They have to have sort of certification, okay, showing swimming proficiency. then we can't require they be accompanied by an adult. So that's essentially how that would work. What's the definition of CGL? So that's commercial general liability policy. That is the general liability policy that you would get for incidents in common area, like slip and falls and things like that, and allegations of wrongdoing by the association. Let's see. Can a manager be liable for board members who act against their recommendations and do something not allowed legally? I think it depends. Normally, if the manager is saying, hey, don't do it, and the board does it, and the manager can show that they said, I did, don't do it, then typically managers would be, I think, protected from liability. Doesn't mean you won't get named in a lawsuit as a manager. But if, the manager is like, yeah, go do it, you can do this, and the board relies on something the manager said, then that could be an exposure to liability. We got 5 minutes. With a fitness room, is it best to have a waiver signed by participants? Again, I think we already talked about that. I would rather you have a use at your own risk type of a sign than having somebody sign a waiver. Let's see. If an association approves an owner's request to install a swing on their deck, which is a limited common element, and the guest of that owner is injured while using the swing, could the association be held liable, or would liability generally remain with the unit owner? It should generally remain with the unit owner if the unit owner is responsible for the maintenance of that swing, and we're not the ones taking on that responsibility. And generally, also, most associations' documents say that we are not reviewing your request for architectural soundness or engineering soundness. We are only reviewing it for aesthetic reasons. So, assuming we have that language, and usually I recommend getting some sort of a written agreement when you allow installation that basically says you're responsible for this. The association has no responsibility. You insure this, you will get your own liability coverage. And then what we do is we record that agreement with the county so that all future owners of this property are on notice that the association isn't responsible for the swing. That's all theirs. Okay. RHOA occasionally receives complaints about snow removal crews starting very early in the morning. Our position has been that starting early helps reduce slip and falls risk and minimize liability, since it can take several hours to clear all the walkways and common areas before residents begin using them. Is this a reasonable and defensible position from a legal standpoint? I mean, it's one of those that I think the judges would defer to because it makes sense. And I think in many cases, my experience has been that associations really have no control over when their snow removal company gets there. A lot of times it's just based on their schedule and we can't control it. That being said, you're always going to see those slip and falls, and they're all going to say you didn't properly clear the snow or you didn't do it in time. There's always going to be those allegations, and it's going to come down to the specific facts of a situation. And kind of what those facts are, because you can change one fact and you can change the liability exposure. How would an attorney, this last question I think we have time for, how would an attorney gently tell a board member that their actions are outside the realm of reasonable actions by a board member? I usually tell managers to say, hey, why don't you consult with legal counsel on this before doing it? I have a feeling this may have some legal implications. I would please consult with the attorney on this issue. That's my general recommendation to do it. And then if the board member says no, all you can do is recommend, but generally that's what I would do. But again, I'm not a community manager, and I know that different community managers have different protocols on how their companies handle that. So obviously, don't take this as you should do this in all cases. Make sure you are talking with your powers that be at your management company as well. Okay. Oh, wait, let's see one more. Okay, no, we did this one already. Okay, if I missed any of you, here's my email. Feel free to email me questions that I may not have gotten to. I think I got most of them, but and I'll try to respond within the next couple of days. I'll get to them as quickly as I can. But otherwise, thank you so much for attending. It's 1 o'clock. We're done. Please answer the questionnaire you get once we sign off. Thanks, everyone.